This is what happens when second chances run out. We're in the courtroom with Audriana Harrison, a defendant whose file reads like a case study in escalating violence. She's already on bond for a terrifying charge, assault family choking, but she's not here for that today. She's back because while out on bond, she racked up a staggering list of new violent offenses. The prosecutor is about to lay out a pattern of behavior so alarming that the judge, who seems to have seen it all, is about to take direct and immediate action. The tension in this room is about to go from 0 to 100. Miss Harrison's freedom is hanging by a thread, and the judge is holding the scissors. What you're about to witness is a masterclass in judicial authority when a defendant's actions prove they are a danger to the community and themselves.
All right, Audriana Harrison. And is there someone from the state?
Yes, sir.
All right, what is happening with this case?
Judge, she has 3 new arrest cases, and then there's 3 sealed at large cases. Mr. Cox doesn't have, I guess, the discovery on all of the cases because all of them haven't been indicted. None of those new cases have been indicted yet.
Let's break down what we just heard, because that list of charges is an absolute bombshell. Assault, family choking, burglary of a habitation with intent to commit assault, 2 violations of a protective order, and 2 cases of continuous family violence. This isn't just one bad day. This is a pattern. The prosecutor is painting a picture of a defendant who is completely undeterred by the legal system. She was given bond for a serious felony, and the state is alleging she immediately went out and committed even more serious felonies. Notice the charge: violation of bond or protective order. This means a court had already explicitly ordered her to stay away from someone, and she allegedly ignored that order with violence. This puts the judge in an impossible position. How can you trust a defendant to follow any court order when they've already violated the most serious ones?
So I'm in the process of right now downloading onto a flash drive the reports and the photographs as it relates to each case, so that you can review that discovery.
Okay, so when is that going to happen?
As we speak right now, Judge, I'm downloading it on the flash drive.
And what are the alleged new cases?
So they are one assault family choking, 1 burglary of a habitation with intent to commit assault, 2 violation of bond or protective order by assault or stalking, and then 2 continuous family violence cases.
Okay. And so obviously someone else set bond in those cases and not me.
Yes, Judge.
This is a massive turning point. The judge just revealed she personally issued the warrant for Miss Harrison's arrest, and now we know why. It's the same complainant. This detail is critical. It confirms that the person Miss Harrison was on bond for allegedly strangling is the same person she is now accused of repeatedly terrorizing. The judge isn't just looking at a list of new charges. She's seeing a targeted, relentless campaign of violence against a specific individual. Her decision to issue the warrant herself signals that she views this situation as an active and ongoing emergency. The defense attorney's attempt to argue that the charges are duplicated is a weak volley against the clear evidence of a defendant spiraling out of control, and the judge isn't buying it for a second. The system gave Miss Harrison a chance, and in the judge's eyes, she used it to escalate the danger.
All right. All right, Ms. Ferguson, I want this set for a contested hearing, and there will be no further resets for this contested hearing. Can we do this mid-November, please? Okay, then she'll be going into custody. I know, I just did mine. Here's the thing, I'm not in charge of whether you have a warrant or not. And your attorney will have a chance to check on that. So what date, Ms. Ferguson? November. All right, Mr. Cox, we'll be back on November 15th, and if you'll speak with the clerks, they'll find out why there's a warrant. Ms. Harrison, I'm the one who actually issued the judge's warrant, and I can tell you, counsel, the reason why I issued it. It was because she's on bond for assault, family choking, strangulation. And then I had a report that she has the continuous violence against family. and violation of bond and protective order. And it's the same complainant.
In those cases, will be, like, it's a way that the DAs, when they file for the charge or when the police officer charges, that duplicate the charge. They charge it.
I've heard of that.
Yeah, they charge you with continuance on the same actions that you've done.
Well,
So they get two cases for one.
I mean, technically you have to have a previous that's not adjudicated, so it's really not the same.
So you, counsel, are you saying the assault family choking is the same as the continuous
It's the
violence?
same charge. If you look at the same offense, it's the same charge, the same actions. You do the same act and you get two charges.
They're not.
Yeah, I think the offense date may be different, counselor. No, I have the offense date for the,
With the defendant now in custody and the stage set, we jump forward to the main event, the plea and sentencing hearing. The previous scene was the appetizer. This is the main course. The state and defense have reached a new agreement after the judge previously rejected their first offer. This tells us the judge is not a rubber stamp and is determined to see a just outcome. Adriana Harrison is about to formally plead to these incredibly serious charges. All the legal maneuvering is over. Now she stands before the court to face the consequences of her actions. Pay close attention to how the judge navigates the formal plea process, because every question and every waiver is a final confirmation that Ms. Harrison understands the rights she is about to give up for good. The fate of her next 5 to 10 years is about to be decided.
assault family choking, July. And the offense
No, I
date.
mean, I'm saying the rest of.
Oh, you're talking about the continuous violence and
Correct.
violation bond. Okay,
Yes, ma'am.
all right.
Yeah, so, my position, Judge, on terms of bond, I know the court would bring it about bond, and my position would be, that there's some concerns, as was always, we were asked that, to be, first on mine.
Well, what we can do,
But I'm not sure on that.
we can set it for a hearing, because once I've remanded without bond, I need to know more about your client if I'm going to consider a bond. And that will give the state a chance to get their witnesses. So if you want to speak to Ms. Ferguson about having a bond hearing, and Ms. Ferguson, well, I have to get the information back from the PR bond. And of course, I'm not going to grant her a PR bond, but a PR bond application is the quickest way I can get the information that the legislature says that I need in order to set bond. So, Ms. Ferguson, can you find out what's the quickest date we can do that? And then we'll take that up, Mr. Cox. Yes.
So that information is generated rather quickly over here.
Oh, yes, yes. So as soon as I have that, then if you all agree on a bond, then of course I can review that and decide whether or not I'll go along with your agreement. If you don't agree on the bond and I'm going to set a bond, then I'll make a decision on that. We just need the criminal history, because I'm not going to grant her a PR bond.
She says.
But here's the thing, I need more than that. The legislator requires that we have information on whether or not they've ever missed a court hearing on every case. And so the PR bond gives me that information. But it shouldn't take that long. They usually do a very quick turnaround.
So. We don't have a date.
Oh, Miss Ferguson will let you know as soon as it's here. All right, court is calling 2023 CR 9045W and 2022 CR 10906W, State of Texas versus Adriana Harrison. Can I have parties announced for the record for the state?
Anna Joey Nelson for the state.
Denny Callahan, defense.
Are you Miss Harrison?
Yes, ma'am.
All right, we were here previously and the court informed both parties that I would not be accepting the plea bargaining agreement. It's the court's understanding that you all have reached a new agreement. Is that correct?
Yes, Your Honor.
We're going to proceed first in cause number 2023 CR 9045W. Counsel, have you received all the discovery in that case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Harrison, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Harrison, I'm going to show you what's entitled Court Admonishments. Well, let me backtrack.
But Ms. Harrison just pleaded no contest. This is a crucial legal distinction. A guilty plea is a direct admission of guilt. A no contest or nolo contendere plea means the defendant is not admitting guilt, but accepts that the state has enough evidence to convict them. They are choosing to accept the punishment without fighting the charges in a trial. In many cases, it's a strategic move to avoid a drawn-out trial they are likely to lose anyway, especially when a plea bargain is on the table. Here, it's part of a deal for 5 years in prison. But notice the judge's meticulous process. She confirms Harrison understands she's giving up her right to a jury trial, her right to confront witnesses, and her right to remain silent. This is to ensure the plea is knowing and voluntary, protecting the verdict from being appealed later on these grounds.
Ms. Harrison, this case was not indicted, although I know the rights and waivers have been tendered to you. I'm going to go over those again. Do you understand you have a right to have the grand jury hear any evidence in this case and make a decision on whether or not to indict?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you understand your attorney has certain rights, namely 2 days from the presentation from the information and 10 days from the presentation of the information to prepare for trial?
Yes, ma'am.
Did you understand that by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
And did you review the information with your attorney and did you understand it?
Yes, ma'am.
And counsel, do you waive the reading of the information?
Yes, Your Honor.
State, are you proceeding on the information as presented?
We are, Your
Going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney?
Yes,
Did you
ma'am.
understand it? Did you
Yes,
sign it
Yes,
in
ma'am.
all the appropriate places?
Yes, sir.
Okay. Did you
This is an incredibly bold last-ditch effort from the defense. After agreeing to a 5-year prison sentence and having his client plead no contest to that agreement, the attorney immediately pivots and asks the judge to completely ignore the deal and reinstate her probation. He's essentially saying, Your Honor, we agree to this 5-year sentence, but pretty please, don't actually do it. He's trying to use his client's self-rehabilitative efforts in jail and her mother's presence as mitigating factors. This is a classic Hail Mary pass. The lawyer knows the plea agreement contractually allows his client to make this request, but it's a long shot. He fulfilled his duty by securing a predictable plea deal, and now he's trying to score an unlikely miracle. Will the judge be swayed by this emotional appeal, or will she stick to the cold, hard facts of the case?
understand you're charged with the offense of aggravated? I'm sorry, you all don't talk behind the court reporter.
The defendant's apology was short and directed at her daughter and the court, but now the judge is cutting straight through the formalities. She isn't interested in a generic apology. She wants to address the terrifying core of this case. Her question, why do you have a knife in your hand? Explain it, is a masterstroke of judicial confrontation. She's forcing the defendant to face the single most disturbing image from the police report, an image of her armed in the presence of her 2-year-old child. This isn't about legal procedure anymore. This is about accountability. The judge is stripping away the legalese and demanding a human explanation for an inhuman act. You can feel the entire mood of the courtroom shift in this moment. Ms. Harrison is no longer a case number. She is a mother who has to answer for the trauma she inflicted on her own toddler.
Right here, excuse me.
Mr. Meadows. Mr. Meadows.
Thank you. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, you're to be sentenced to 5 years in the prison. There's an affirmative finding of deadly weapon. There are no applications. The state will
What a powerful and devastating lecture. The judge isn't just sentencing a crime, she's diagnosing a generational curse. Her speech about the cycle of violence is aimed directly at Audriana Harrison, but speaks to a much larger truth. She paints a vivid, heartbreaking picture of Harrison's daughter, now 2, potentially ending up in the same courtroom years from now, citing her mother's violence as the root of her own problems. The judge's warning about becoming a habitual offender facing a minimum of 25 years is the legal hammer. But her words about the child learning violence by seeing violence is the emotional and psychological anvil. She is making it painfully clear that this sentence isn't just punishment. It's a desperate attempt to quarantine the defendant's behavior before it permanently poisons the next generation. This is a judge who understands that her rulings have consequences that extend far beyond the courtroom walls.
Taking consideration 2023 CR 10983. Is it everyone's intention that this case, if I follow the agreement, is to run concurrent with the probation case?
Yes, yes,
Right.
Your Honor.
And then it will be concurrent with cause number 2022 CR 10906W. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes,
And also, is this a family violence case?
it is a family violence.
All right, did you understand if the court, from reading the stipulations or any evidence that's presented, if I determine that this is a family violence case, then I will enter an affirmative finding of family violence. Did you understand that?
Yes, ma'am.
And did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
All right. All right, then to the offense as charged, how do you plead? Guilty, not guilty, or no
No
contest?
contest.
State any evidence?
State offer states exhibit one with attachments.
Any objections?
No
Oh,
objection.
sorry, Judge. No objections to comment.
No, you're
No
offering
objection.
states exhibits one and attachments?
Yes, Judge, it's been a long day.
No problem. Any
No
objections?
objection,
All
Your Honor.
right. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments and review the same. All right, after reviewing states exhibits one and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Pursuant to our agreement, Your Honor, Ms. Harrison has a right to ask you to bend the plea agreement and give her, or rather reinstate her probation. And that support thereof in the PSI, it shows that they say she didn't have a mental health or didn't take mental health treatment because she attempted suicide, but she did. I want to make that correction.
With a 5-year prison sentence delivered for the aggravated assault, the court immediately pivots to the older case, the continuous violence against family for which Ms. Harrison was originally on probation or community supervision. By pleading true to committing a new offense, she has automatically violated the terms of that probation. The judge is now granting the state's motion to revoke it. This means the original deferred adjudication is gone, and she will now be found guilty and sentenced on that charge as well. The key here is the phrase "run concurrent." The new 5-year sentence for the probation violation will be served at the same time as the 5-year sentence for the aggravated assault. They don't stack. This is an efficient way for the court to resolve all outstanding issues, closing every loophole and ensuring Ms. Harrison serves a single comprehensive sentence for her entire pattern of criminal behavior.
In her hand are 2 completions of self-rehabilitative efforts in the jail of family violence. But she has a right to ask that outside of the agreement of
Yes.
5 years. I asked the court to follow the agreement, but perhaps to consider taking both cases and putting her back on probation. Lastly, her mother's here in court and supports her. That's a good sign. Because of her past, she still has not thrown in the towel for her daughter. Do you want to talk to the judge?
Yes, sir.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Adriana Harrison.
All right, defense.
May she make a narrative statement, Your Honor?
State, do you have any objections to the narrative?
No objection.
All right,
I just want to say I apologize for my action. I just want to say I apologize for my action on my behalf with my daughter. I owe her a deep apology for acting the way I acted. And let's just say sorry to you for ending backing up in front of you.
In the end, every appeal for leniency was denied. Adriana Harrison was sentenced to 5 years in prison with her probation revoked and both cases running concurrently. The judge's final off-the-record words were not of condemnation but of stark, brutal advice. Get your life together before you re-enter anyone's life, especially a child's. She powerfully articulated how violence is a learned behavior and how Miss Harrison's actions were teaching her daughter that violence is how you solve problems. This case serves as a grim reminder of how quickly a life can unravel and the generational impact of domestic violence. The judge made it clear that the system's primary duty is sometimes to create a firewall to protect the innocent, even if it means sending a mother to prison. What did you think of the judge's final lecture? Was it a necessary reality check or overly harsh? Let us know your thoughts in the comments and subscribe for more in-depth courtroom analysis.
Judge, and for you to please give me another chance.
All right, what's your daughter's name?
Ariana,
I don't, nothing further, Your Honor.
All right, anything from the state?
No, Judge.
All right. You want to explain that to me?
I'm trying to get my daughter back.
No, why do you have a knife in your hand?
Explaining this.
And how old is your daughter?
She just turned 2.
All right, so do you realize that your daughter remembers you with a knife in your hand?
Yes, ma'am.
You need to work on your anger issues because this isn't the first time that you've been to this court for anger issues. And I know your mom says, well, would probably say, oh, she needs help with her mental health or she needs help with her drug issues. That's what I was giving you when you were on probation for that. And you didn't take advantage of it. You just doing whatever you want to do. So I don't know where your anger issues stem from, but you need to get those under control because otherwise, you know what's going to end up happening? You're going to end up being a habitual. You know what that means in Texas?
Yes, ma'am.
That means if you pick up another felony, depending on the type of felony, your minimum is 25 years in prison.
Yes, ma'am.
And then if you go to prison for 25 years, when you come out, your child will be an adult. Hopefully your child will not be before a judge with a defense attorney saying, oh, my mom pulled out a knife when I was 2 years old and I was there to witness it and she was being violent to her girlfriend and she went to prison. So I didn't have anybody to raise me. That's what's called the cycle. And that's what ends up happening when you do these things.
Yes, ma'am.
All right, the court will follow your agreement, sentence you to 5 years in the prison. There's an affirmative finding of deadly weapon. There's going to be an affirmative finding of family violence. Take in consideration 2023 CR 10983. This will run concurrent with 2022 CR 1090W. There's to be no contact with Diamond, D-Y-A-M-O-N-D Jones, Dylan Angeles, D-Y-L-A-N-A-N-G-E-L-E-S, and there's to be no unsupervised contact with minors. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Could you pass that, please? Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because it's a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we're going to move on to 2022 CR 10906W. I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Adriana Kisna Harrison who was placed on deferred adjudication in 2022 CR 10906W for the offense of continuous violence against family on November 5th, 2022 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 6th day of September 2023 in Bexar County, Texas. The defendant, Adriana Kisna Harrison, committed the offense of aggravated assault with a deadly weapon in violation of condition number 1.
How do you plead to that? True or not true?
The state waives and abandons all remaining alleged violations.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Your Honor, we would ask that you revoke probation at this time, that the defendant be sentenced to 5 years in TDC and that it run concurrent with her other aggravated assault with a deadly weapon, which you just sentenced.
All right, is that the agreement?
Yes, Your Honor, as pursuant to the agreement, she's permitted to ask you to ignore it and put her back on probation, nothing further.
All right. Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then the court will follow your agreement. The court will grant the motion, find you guilty, revoke, sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with, I think it's Taquidra, Taquuiedra Evans. There's to be no unsupervised contact with minors. And I'm sorry, what was the cause number for the other case? Does anybody know offhand?
The one,
Yes.
2023 CR 9045W.
And it's to run concurrent with 2023 CR 9045W. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. You're gonna have to do better. And obviously, you should not be in any relationship with anyone until you get your life together. And you should not be in a child's life until you get your life together, because children learn by what they see and what they hear. When you see a child who's using profanity and they're young, they didn't just like all of a sudden start using profanity. The people around them use profanity. And when you have a child who sees violence in their life, they start thinking that's the way you solve problems, by using violence. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
You're welcome.